First of all, it's very, very nice to be here. I think this is exactly the kind of thing that Bar-Ilan should be doing, and it should be supported. When I got this case, I showed it to one of my legal assistants, and he said, what kind of question is this? So I said, welcome to John Lockie's mind, but the truth is that his mind is expanded by what's possible. It's just staggering. From a legal point of view, I'll just say one comment before I talk about the case. In most legal systems, it's known that a very difficult problem is the issue of paternity. There are a lot of paternity suits all over the world. There aren't that many maternity cases. Who your mother is, you could know. There was one exception, one notable exception, of course, the story of Shlomo Melech with King Solomon. But there, if we analyze the story, the problem is that King Solomon doesn't know all the facts. There is a clear answer. And the question is, how does he get to know the facts? Now we'll take a very simple case, something which I understand to be possible. You take a woman who wants to be pregnant, and her egg is not quite perfect, so to overcome that problem, they take the nucleus of her egg, they combine it with another woman's egg, then the new egg, they do what they have to do, and then they impregnate the result in a third woman. Now you have 3 women that are participating in the birth process. Who's the mother?
One more mother, you have the nation of Israel.
You have the nation of Israel. Who is the mother? And the question, and what's interesting about the question is, unlike the story of King Solomon, we have all the facts. I've given you all the facts. Everybody knows. We don't have to do any exploratory process to determine the facts. I know what the facts are, and the question is difficult. And this is the kind of thing that the law has to deal with. And these issues are very, very difficult, and they're changing all the time. And these are essentially worldwide questions that have to be dealt with. I believe, and I'll try to demonstrate that in all these issues, Jewish law has a great deal to contribute. Now, if we talk about the question, I'll first speak about it very briefly from the point of view of how the law would look at it, how the secular law would look at it, how legal systems would look at it, America, England, Germany, Australia. You're talking about a question that, there are certain questions that would arise immediately before I get to what Jewish law would have to say about it. One, to make the question even more interesting, as if it's not interesting enough, let's add the following scenario to the question. The mother, or Mrs. Moel, Mrs. Cohen, is quite appalled at what has happened, because she's told that if this process takes place, what will happen is that her 8-day-old baby will be the father, the genetic father. And she does not want the child to be a father. But in any event, she agrees to carry the baby to term, and she wants to carry the baby to term. Now you have a very interesting abortion question. Let us assume that somehow the court learns of this. The court appoints someone to represent the 8-day-old baby and asks to stop the pregnancy. The reason the court is asked to stop the pregnancy is because they do not want the child to become a father and to have this responsibility. I don't even know what the responsibility would mean at such an early age. What would the court do in this case? Now, there have been cases of stolen sperm. There have been cases, there's a case in America where someone had oral sex with a woman. The woman took the sperm and then impregnated herself through a process. This is an actual case in 2005. And then the father wanted to stop the pregnancy. The court said that you cannot stop the pregnancy because of the fact that the sperm was given to the mother as a gift. That since when the act occurred, the male did not say, I'm giving this to you on condition that you don't make a child from this, it's viewed as a gift. Of course, this evokes certain amount of smiling and laughter because it's obvious he never thought of such a possibility. It's quite obvious they didn't consent. This is sort of a fiction. What the court is really saying is that we will not stop a woman from going full term in a pregnancy unless she herself wants to, and then we'll discuss the issue. But we will not, and that's the common view all over the world about stopping pregnancies. And they say even if the husband did not know, he still will have financial responsibilities as a father. You take a more extreme case, let's say where the husband was sleeping, or the father was sleeping, the potential father was sleeping, and then the sperm was taken out of him, so there's no way that he gave it as a gift, the result wouldn't be any different. It could be that maybe after he's ordered to give child support, that he could then sue the mother back for child support. That's about as far as it would go. Here you have an interesting case where the court would have to deal with a new issue, which is the interest of the mother, of the woman, to continue to pregnancy, full-term pregnancy, versus the interest of the child not to become a father. That's a stronger competition than the usual competition between a male, adult male who does not want to be a father, and an adult woman. We now have a bigger problem. We have a new problem, and it's a little scarier, it's a little trickier, but I think even now, the court would not do anything to stop, most courts would not interfere with the pregnancy, because that would be an overriding view. Yes?
But what if there was a fertilized egg in IVF process, like the Tahmani case?
Yes.
And the representative of the baby want to stop to destroy the zygotes.
Yes, so that would be a different case. Before she actually became pregnant, they would think there, since the case as it was decided in Israel was very, very close, it would seem to me that if a child was involved, that the decision would go towards the child. But once the woman was in the process of being pregnant, I don't think the court would interfere. Why not? Now, this is something which I'll get to, which connects with Jewish law. The reason is because of the right of privacy. The right of privacy is a very big issue now. The right of privacy has become the solution to all problems which you don't know how to solve in most legal systems. And therefore, the woman has a right to have an abortion or not to have an abortion based on the right of privacy. Privacy did not exist before the 20th century. If I said to a legal scholar in the 19th century in England about the right of privacy, he would have no idea what I was talking about. It would mean nothing to him. And now the right of privacy is the reason, for example, why American Supreme Court decided in the case of Lawrence that you cannot tell two people, you cannot make a law against having homosexual relations in the home because of the fact that the state cannot interfere with the privacy of the individual within their own house. And it also was why women are allowed to get contraceptions. Privacy now has become something very, very broad, and in a certain sense, it's a very good solution, because no one really knows what the right of privacy is. And if you have a difficult question like this, and you want to come up with a new category, and that's so defined, that it's not so clear, privacy does the trick, privacy does the work, and therefore privacy is a very, very good thing. If we talk about this particular case, so a view might be that privacy is involved, but somehow the right of the child has been, his right to privacy has been harmed. Because you have a problem, what damage has been done? This is also a question. Damage is defined by the negligence law of England is the loss of life. Here, no one is losing their life. It's the opposite result. Someone is gaining a life. So who has been harmed by this? So it seems that the one who's been harmed by this is the child, because he's forced into a position that he doesn't want to be. And therefore, the right of privacy would be very, very useful. You could have other solutions which you could make up new categories of crime. You could call it genetic rape. For example, what's happening, it's difficult to call it rape of the child because you can't have rape of a child, and it had no physical contact in any sense. That's why the example is very clever, because talking about the foreskin, which is no longer part of him. You could also talk about identification theft. You could make up new legal categories, which perhaps the law would do. But I think if the case came up, so they would use the rule of privacy as an infringement on the autonomy of the individual. If I were to say to someone in America or in Germany, where these concepts are very, very developed, more so than other legal systems because of the Constitution, they would say, well, what else do you suggest? And if I would say theft, they'd say, no, the problem isn't theft. Do you really think it's that the fact that he sold this foreskin is something that anybody really cares about? Let's call it what it is. It's really affecting someone's autonomy. It means that he is against his will, is forced to be a father, and therefore that would be the appropriate category. Yes?
And if you decide that he's not a father, you sever the connection between the baby and the embryo. Do you solve this problem?
Yes, the problem with that, it'd be very difficult to say he's not the father, because on some level he is the father. So let's say, for example, that it's a problem that he won't have to pay alimony. They're the same age. He's just 9 months and 8 days older than his, his brother than his son. But the thing is that, let's say he's an adult now, and he's a very rich, the father is very wealthy, and the son is having a great deal of difficulty. He wants help. You cannot, the law could say it, but the question is, you would also place a moral burden on him, because he could say, or his representative say, you could tell me I'm not the father, but I am the father, and therefore I'm forced in a position where I do not want to be. So moving along, we now get to now this example of autonomy is not something that Judaism can live with very well on one level. Rav Soloveitchik once said that the category of Kvod HaAdam, the dignity of man, or as it's actually characterized in Halacha, Kvod HaBriut, the dignity of men in plural, of creatures in plural, is something which is very central to the posek. He said when the rabbi makes a decision, this is what Rav Soloveitchik says, he says the rabbi makes a decision, he may not use that category, but it's something that very much affects how he resolves an issue, and this is what Rav Soloveitchik said. And so therefore the notion of autonomy, we don't really have to learn from other legal systems the importance of it. It amuses me somewhat when Israel or certain secular judges or lawyers are so proud of the concept of Kvod HaAdam, when actually we have the Kvod HaAdam and Kvod HaBriot actually in our own sources, and that's where it comes from. But I would argue that I think it's important for something so horrific and something so extreme that we not call it an infringement of privacy. We not call it a problem that the autonomy of the individual is being affected, but rather use legal concepts that should be expanded. For example, theft. I think that if you call someone in this category that you tell him you have infringed upon his privacy, that's much less powerful than calling him a thief. And calling him a thief, I believe, is more of a proper response to what he is. Now, when I say a thief, I'll use the concept of a ganav or a gazlan without getting to the differences between the two interchangeably. And you could say to me, well, in what sense is he a thief? What did he take? He takes something that the person that was given away. So how did he steal? In what sense did he steal? I would argue, and this is something that's very, very important. Rav Lichtenstein wrote a very interesting book on grame. Grame is the issue of causation. In Jewish law, causation is a very, very strict concept. And you have to have very, very direct causation. And it's very difficult in many situations to say that someone is guilty unless you have very, very direct causation. However, Rav Lichtenstein at the end of this book mentions, where he wrote the concept of grame according to the Ramban and the Ri, he says that in today's world, someone could steal money from a bank, rob a bank, without going into the bank, just by using the computer. And he could do it in such a way that it would take a certain amount of time and so forth. And it could be, he says, that fundamentally, according to the categories of theft, as we define them in halacha, that maybe he's not a thief. But the point is, and this is what I would recommend, that it'd be better, I think, morally and in terms of what actually it is, to deal with the category as theft. And as Rav Lichtenstein says, the challenge awaits poskim to do this. In other words, this is something which one has to really think about. It's not unprecedented. If you study in Maimonides' laws on murder. So he has in the beginning chapters 2 types of murder. There is the usual case of murder. If someone walks up to someone else, shoots him with a gun, he is a murderer. What about the category where someone tries to convince someone, seduces someone else, or convinces someone else to murder the other person? What if, for example, I leave the room, and once I'm out of the room where a person's in the room, I push a button, and a lion then, who's very hungry, is left alone with the person, and the other person dies. Have I committed murder? Now it could be, again, according to strict laws of causation, I haven't, because I myself just pushed a button. The button in itself did not cause the murder. But the Rambam, very interestingly, there calls this kind of person a murderer, and says that we have to view him this way. This is the beginning, for those people who want to check, the beginning chapters of Hilchot Shmirat Retzach and Shmirat HaNefesh. Actually, this idea I brought in a case which was given a few months ago in the Supreme Court, dealing with the question of causation, when both someone stabbed a person and then afterwards he was mistreated in the hospital, and the one who stabbed him 25 times said, the hospital messed up, you cannot find me guilty of this crime. And I mentioned this view of the Rambam. The Rambam says that we have to do certain things in order to deter people from doing from getting away literally with murder. So I mentioned these examples. I also think with theft, Rav Ariel wrote an interesting article for Tchumim where he talks about the stealing of a woman's egg, and he deals with the question of whether it's theft or not. He says it's a problem with it may not be theft because perhaps the person doesn't own his body. This is a very interesting question which Rav Zevin and Rav Israeli dealt with, whether a person owns his body. Perhaps you're not stealing something which really can be stolen. That would be the German approach, that to say that the body is an object is somehow demeaning the body, the present German situation. However, Rav Ariel discusses there that there are other categories. For example, the thief who steals from a thief is viewed as a thief, even though it's not clear he's stolen anything from the owner. The owner is no longer better off or worse off than this. And it gives us as an example that you can have the crime of theft without having an object which was stolen. It's a very interesting concept, and it's a direction which I would suggest we go for. Of course, I'm aware of the fact that in the case there's a problem of fraud because the person took the item without, by consent. No one said you can't take the item because he's not aware of the use of the item, but also there are recognized categories of theft by fraud. There are other types of examples that one could use. You could call it an assault. I think that's less appropriate because of there not being direct contact between the mohel and the mohel and the baby. We must remember also that gneva. This is with this I'll close. That gneva, even though it seems to be just about objects, halacha was very, very creative about the crime of theft. And about the crime of assault. I'll give one example in each area. In the area of the crime of theft, it's mentioned in Tosefta that there are 7 different types of thief, of stealing, of thieves, and the one who is the biggest thief is the one who's gonevet hada'at, that steals, I guess, the knowledge of the person, and in some sense fools the person. Da'at is not a good definition. I'll accept a better definition if someone has it. But gnevat da'at is a form of theft. Information theft. Yes, you call it information theft, and here we're talking about certain concepts really would expand. I also recently read something, Rav Elyashiv talked about the fact that while you're on, without not to open this up to a discussion, but while you're on a plane and you want to, in the middle of the flight, go to the end to daven, so he talks about the fact that perhaps this shouldn't be done because of the problem of gnevat sheina, the problem of stealing sleep. So I think if you could steal sleep and you can steal information, I think that this should be recognized for what it is, and strong terminology should be used. In terms of the assault, I'll just mention something interesting which may or may not be relevant, but I'm just trying to show how things can be used very creatively. Rav Singh talks about the fact that when the Bet Din, the court, gives 40 lashes, and then instead of giving the amount required, gives an additional 3 lashes, you're responsible not for the 3 lashes beyond what you're allowed to give. The person was found guilty by a court. He had to really have the lashes that he's supposed to get. And then the one who's inflicting the lashes decides to give a few more lashes. Bioethics pointed out that in halacha you're responsible for all the lashes. Why are you responsible for all the lashes? After all, the first part of the lashes that you gave, you were allowed to do. But it's, again, a sort of fraud now has appeared retroactively, which affects the permissible action and now has changed it. That's what I would say about the fact that he took it and it would be allowed to. So in summary, because I want to, very anxious to hear of Rav Abraham what he has to say, I'll just say that in summary, it seems clear to me that the regular legal system, the normative legal systems in the world today would quickly respond to this question, probably in the ways that I spent before. In terms of halacha, I think that it's important not only to find a way of saying that it's asur, because it's asur, that it's not allowed, but perhaps calling, what they say, the yelek b'shmo, calling the act for what it is, realizing what it is, and putting it in the proper category of criminal response. The final point I wish to make is one of the thoughts that I had when I read this question, I read the case several times to actually believe that this was the question. One of the things I always thought was interesting was when I learned the 10 Commandments as a child, so there of course is lo tignov. And then on some level I was disappointed to find out that lo tignov doesn't mean that you steal property. It means that you steal a nefesh, that you steal a person. Okay, so lo tignovo includes other forms of theft, including gnevat dat. But the thing is, I thought this is an interesting example of stealing a nefesh in a different way than we have previously understood it. It's also a different way of yeush shalom mida'at, of when you despair of a property without realizing what it is. It opens up, and one of the interesting things about these kinds of questions, it really expands our understanding of categories that we're familiar with. And I would suggest that the direction that I personally would like to see would be that the halacha would be able to be flexible enough and direct enough to deal with the crime in the proper way, in a way that perhaps would give it the intensity and the social criticism and classification that it warrants. Thank you. Yes?
That's my point. The theft must be that they take something from you and you don't have any more. So you cannot separate the issue from theft from the issue of toll, from the issue of damage. If there was no toll, no damage, then there was no theft in this case.
Yeah, so again, it's mentioned actually a little bit, it's an interesting thing in Rav Ariel's article. So he mentions, for example, about Rachel, Rabbi Akiva's wife, selling hair, and did she have the right to sell hair and make money from it, and does it belong to her? And of course, you have many, many hairs. I would just say that perhaps, while what the Rav is saying, of course, is true, it would seem to me that to say it's not a tort and that it's something that should be not done because it's not appropriate or something along some general category of sita hayashar v'atol v'after echa kamocha, some general category of you should love the neighbor as yourself, you should do the right thing. To my mind, it wouldn't be enough, and perhaps because we're used to looking at it from the beginning, which is what you're talking about. I think you should look at it in terms of what it causes, and because of what it causes, perhaps it should open up a different way of looking at it. To my mind, and of course there are greater rabbinic experts here than myself, to my mind, the Gemara, when it came to dealing with a lot of these questions, was very, very interested in terms of the result of what it was deciding. It's not a question of what's chametz and what's masa in terms of categories that are very defined by the Torah, and they looked at it as such. There was the view, I think, to some extent was broader, and therefore I would suggest that this is a very good area to do the same thing, to achieve the correct result, and not just leave it as something that you're not allowed. And other legal systems go further. I think that this is a chance that Kadesh Tashem, in the sense of to show that the halachic system, and this I believe, really has the ability to deal with these questions as well. Thank you.
Judge Hendel, before we go to Rabbi Abraham, just 1 second, just to finish, really, in a way, to clarify. If the woman wished to carry this baby to term, and the charismatic Rebbe wanted her to abort, just hypothetically, or let's say it weren't the charismatic Rebbe, let's say it was a charismatic rock star, who wanted her to abort, would you rule then you would rule that she could be forced to abort? Is that correct?
Yes, it would seem to me that modern legal systems would not recognize the right to force a woman to have an abortion.
What would your opinion be?
I think it would be difficult, really, to force a woman to have an abortion. The question is whether there's any precedent for that. It's a very interesting question, and I don't really see that there's such a basis for it. And it seems that there's a view that the fetus, to some extent, at an early part is part of her body. It would be a very, very difficult result to justify, and a very, very extreme kind of result. And I don't think that would go. Also take into account that, of course, the better person to make the argument would be the child. If the child making the argument, it'd be more difficult rather than well, he could have a representative of his interest in court. So he could be, his view could be brought. And then you have a very interesting question about whether you can actually abort the child. It would seem to me that it'd be very, very difficult, especially the way abortion laws are viewed today, that to force a woman, yes.
One other clarification. And if the Rebbe wanted to imprison the Moel then and said this is thievery, what would you vote for on the court?
Well, again, the whole idea of what punishment he should get is a difficult problem. The question is, whether ma'asar, whether imprisonment is something that halacha recognizes. People have written that there are certain instances it was used in various ways, and assuming that the punishment, I'll say it differently. If the punishment for stealing $3 million is prison, then the punishment for saying this should be prison as well. It shouldn't be less. In other words, that it should be viewed very, very strictly, very harshly, because it's quite an extreme act, and should be viewed that way in terms of a legal system which really is based on values, where a person's identity is worth more than property.
I'd actually like, John, I'd like to go to Rav Avram and then open it up for questions for both. You have one more? Okay.
From the legal side, suppose you have the other side. Supposing the first baby dies, and now the grandfather would like rights of care for the genetic grandson.
Yeah. So there's the question.
You want to repeat that, please?
Just maybe say it again, because I want to make sure I.
In other words, let's say the infant.
Yes. Which infant? There's two infants here.
The Nemo died.
Okay. The father, let's call him.
Right,
Yes.
the father died. Now the grandfather wants a child, a genetic child, so wants rights to have,
To raise him as a living.
right, to raise him,
Yes.
to share rights with the genetic mother.
Yeah, so then it's a broader question of how Jewish law really looks upon the situation where the parent of a child is no longer alive, and what you do with that. To be honest, Jewish law really found solutions for this problem not in a legal situation. They sometimes say that adoption is something that Jewish law didn't recognize. I don't think that's true. I mean, there's a category that's mentioned about that if you raise a child as your own, it's as if he's your own. And you see this example with Michal. She has children even because she raised Merav's children, even though she herself did not give birth to them. So he would have status, but it would really depend on the question. In modern law, so they think that a grandparent is better. I'm not sure that's always the best case, by the way. I wouldn't make a hard and fast rule, forgetting about the bizarre aspects of this case. But is every time if the grandparent is elderly and it's difficult to raise a child, is he the best person to do it? I'm not sure that the law should always go that way. That's what I would say.
Why don't we turn now to Rav Avraham? You want to sit over here?
טוב, אני מדבר עברית, אז אני אכוון להוציא את כולם ידי חובה, כל מי שלא דיבר עד עכשיו עברית. יש פה במקרה הזה כמה אספקטים שבהם צריך לדון. האספקט הראשון, שבו התחיל גם השופט הנדל, הוא שאלת האבהות. בשאלת האבהות אני לא רוצה להיכנס כל כך, יש עוד דיונים לגבי סתם הפריה מלאכותית, לאו דווקא מאור של עורלה, אלא מזרע זר, ופרופסור שטיינברג מביא את זה באנציקלופדיה שלו, דעות שונות, יש לפה, יש לשם. טיעונים ממש משכנעים לא ראיתי שם בכל מקרה, כמו בהרבה בעיות אחרות, כך שאפשר להגיד כך או כך. יכול להיות שמה שמיוחד במקרה הזה, שכאן ההפריה לא נעשתה מתאי זרע, אלא מתאים שלקוחים מאור. ואולי יש פה איזושהי אפשרות להרחיק עוד יותר את הדעה שבעל התא המפרה הוא האבא. אבל אני בספק רב, אפשר להכניס את זה לתוך אוסף הסברות הלא מבוססות שנמצאות גם בסוגיה היסודית. לכן אני מעדיף להתעסק יותר עם החלק השני. והחלק השני הוא כמובן מה המשמעות של המעשה. האם המעשה הזה הוא אסור, מותר, כתוצאה מזה, האם מאיזה סיבה זה אסור או מותר? האם יש חובת פיצוי? או שאולי לא, זה אסור, אבל אין פה חובת פיצוי. אז כאן צריך לחלק, ואני חושב שבכלל בכנס הזה הנקודה הזאת לא מספיק חודדה, שיש 3 קטגוריות שצריך לבדוק כל שאלה שבה עוסקים. הקטגוריה הראשונה זאת הקטגוריה המוסרית. הרבה פעמים מדברים על אתיקה יהודית, אני כופר במושג הזה, לא חושב שיש דבר כזה. אני חושב שאתיקה זה מושג אוניברסלי, וזו שאלה אוניברסלית, הייתי אומר פה מה שכל אחד אחר היה אומר, לא משנה מה תהיה דתו. השאלה השנייה היא השאלה ההלכתית. השאלה ההלכתית, אני אומר עוד לפני משפטית. זאת אומרת, האם זה אסור או מותר? לא במובן של האם פגעתי בזולת ומה אני חייב לו, אלא האם זה אסור או מותר. והשאלה השלישית היא השאלה המשפטית. זאת אומרת, האם יש פה גם עילה לתביעה של הנפגע, או אפילו לתביעה, מה שקוראים היום זכות מוסרית, אבל זה מושג משפטי, לעילה על זה שפגעתי באיזה שהן זכויות שלו, גם אם אין חובת פיצוי, עדיין יש פה איזשהו סוג של פגיעה שהיא כמו משפטית, כמו חושן משפט. בחוק נדמה לי שעל פגיעה בזכות מוסרית יש אפילו תשלום, אבל בהלכה לא, לפחות מעיקר הדין. עכשיו, במישור המוסרי, כמו שאמרתי קודם, אני לא מתכוון להיכנס. השאלה המוסרית, כמו איך קראו לזה באחת ההרצאות הקודמות, יוקה, משהו כזה, יש איזשהו, ברור שזה מסריח. אבל...
זה יק פקטור.
יק פקטור, אוקיי, יק פקטור.
יהיה מילה בעברית בשביל זה?
משהו מסריח. כן, אוקיי. במישור ההלכתי, גם כן אני מרגיש שהשאלה פה היא קצת בנאלית, כמו הרבה מהשאלות המשיקות, בגלל שלכל היותר אפשר לדבר במישורים של התערבות במעשה בראשית, לעשות משהו לא טבעי, כל מיני המצאות שגם הם, התחושה שלי, קשה לבסס שם איזושהי עמדה חד משמעית. לכן אני מעדיף להתרכז ברובד השלישי, שם נדמה לי שלפחות יש על מה לדבר, ואולי להמשיך את הכיוון של השופט הנדל, ואפילו לתת לו יותר בשר סביב העצם הזאת. לפני שאני נכנס לדבר עצמו, עוד הערה, שגם היא יכולה להיות ברובד המשפטי. אפשר היה לדבר על מישהו שעשה את זה שהוא לא המוהל, אם אנחנו רוצים להיכנס קצת לפרטי המקרה. יש איזושהי תחושה שהמוהל עשה משהו שהוא עוד יותר גרוע מאשר אם כל בן אדם אחר היה עושה את זה. השאלה למה? אז אפשר היה לדבר על סוג של חוזה מכללה. זאת אומרת, שלחתי אותך להיות מוהל, היה לי איזשהו אמון בך, הפקדתי בידך כביכול, כן, את העורלה, ואתה הלכת ועשית עם זה משהו שיש בו מעין מעילה באמון. אבל עוד פעם זה לקחת את הדיון למישור צדדי, בגלל שבאמת ניתן לשאול את השאלה הזאת על כל אחד, לא רק על המוהל. מעבר לזה, גם המוהל עצמו, זה ברור שזה לא היה חלק משליחותו, מה שהוא היה צריך לעשות זה לזרוק את זה. ובמקום לזרוק את זה, הוא לקח את זה, אז מישהו אחר יכול היה לקחת את זה אחרי שזה נזרק. זה לא חלק מהפעולה של המוהל עצמו, הוא היה אולי קצת יותר נגיש לעניין, אבל זה לא חלק מהפעולה שלו עצמו. ולכן באמת אני מגיע לתורף העניין. מה שנשאר כאן בעצם לדון, זה באמת בשאלה של ההזק, או במובן המשפטי, ביחס לתינוק האבא. אז לגבי ההיזקים העקיפים, כבר גם דובר קודם על שאלת הגרמה והגרמי, שיש פה איזה שהם היזקים עקיפים, וגם את זה אני רוצה לנטרל. אני רוצה לנטרל את זה, אפשר בקלות לנטרל את זה, אנחנו נקבע שמשפטית או ממונית, אין לו שום מחויבויות לתינוק האבא. ובכך בעצם פתרנו את הבעיה הטכנית הזאת. זה כמובן קשור לשאלה האם הוא באמת האבא או לא, זאת השאלה הראשונה שאמרתי שאני לא אדבר עליה, אבל אם נקבע שהוא לא האבא זה גם מנטרל את הבעיה הזאת. במובנים היותר מהותיים שאותם פה יהיה קשה לנטרל, זה באמת שאלות שנוגעות יותר לסוג של מושגים כמו גניבה או גזל, מה שגם השופט הנדל דיבר עליהם קודם. אבל כאן נדמה לי שהדברים צריכים קצת חיזוק. הובאו הדברים של הרב אריאל מהמאמר שלו לגבי גניבת ביציות, אז גם כאן אני חושב זאת לא דוגמה מוצלחת. זאת לא דוגמה מוצלחת כי גניבת ביציות, אלא אם כן הביציות האלה כבר נזרקו. זאת אומרת, באיזשהו מובן ביציות שהלכו להן, או כן, כבר הם אחרי התפקוד שלהן בגוף האישה, מישהו הלך ולקח אותם מאיפה שהן נמצאות ועשה איתן משהו. אז אולי זה דומה. במקרה שלנו מדובר פה על משהו שהוא כבר לא חלק מגופו של התינוק האבא, הוא כבר בעצם נזרק, הוא לא מיועד לשום שימוש, הוא לא חלק מגופו, ולכן גניבה במובנה הפשוט קשה לראות פה. אבל יכול להיות שאפשר כן לדבר על גניבה באיזשהו מובן יותר מוצק, אם באמת אנחנו מדברים, והוזכר כאן קודם העניין של גניבת דעת. אבל גניבת דעת באיזשהו מובן יותר מהותי, לא רק כדוגמה. אני רוצה לטעון שהבסיס המשפטי לבעיה שיש פה, ואולי גם למחויבות שנוצרת כתוצאה ממנה, הוא באמת המושג של גניבת דעת, לא כמשל, אלא כעוגן אמיתי. וזה אולי אחד הדברים שמבחינים את ההלכה ממערכות משפטיות אחרות, שמערכות משפטיות אחרות די חופשיות לקבוע לעצמן את העילות ואת הכלים המשפטיים שבהם משתמשים. ולכן הרבה פעמים השיקולים או ההנמקות הן הנמקות טלאולוגיות. זאת אומרת, השאלה היא לאן הדבר הזה מוביל. אם זה מוביל לדברים גרועים, אז אני רוצה לאסור את זה. בהלכה, אחת המגבלות הגדולות של ההלכה, אבל לפעמים המגבלה מובילה ליותר יצירתיות, זה שקשה מאוד לעשות דבר כזה. אני אביא רק דוגמה שאחרי זה תשמש אותי גם באופן מהותי. אגב, את הדוגמה הזאת, פעם ראשונה שחשבתי עליה, הייתה בפגישה הקודמת שלנו. בסמינר של רקובר, שם ראיתי את התשובה שעליה עוד מעט אני אזכיר, התשובה של רב חיים פלאג'י. אז לגבי השאלה של גניבת דעת, אולי, או ההקשר הזה של גניבת דעת, אני רוצה לקחת כדוגמה את העניין של זכויות יוצרים, או קניין רוחני. זכויות יוצרים בהקשרים המשפטיים, הרבה פעמים מטפלים בה במושגים תכליתיים, מושגים טלאולוגיים. למה חשוב לשמור על זכותו של היוצר על יצירתו? כי זה יוביל אותו ליצור עוד, זה יאפשר לו ליהנות ממעשה ידיו. שיקולים שמסתכלים על התוצאות. מה יהיה אם לא נאסור את זה ומה יהיה אם נאסור את זה. אחת האינדיקציות להבדל שדיברתי עליו קודם בין ההלכה לבין מערכות משפטיות אחרות, זה שפוסקי ההלכה, חלק גדול מהם לפחות, מאוד מתחבטים סביב השאלה של זכויות יוצרים, ולא ממש מצליחים למצוא מוצא אמיתי. כולם מבינים שיש פה את היק פרמטר, כולם מבינים שיש פה משהו מאוד בעייתי ושראוי לאסור אותו, אבל כשמנסים למצוא איזשהו עוגן משפטי,